Good. Okay, well, good morning to everybody who's joining us today. My name's Karen Goff. I'm a barrister at 39 Essex Chambers in London, KL and Singapore. So it's my pleasure to moderate this webinar. I'd like to welcome my speakers and all the participants from around the world to the first of the International Construction Project Committee's webinars on the subject of comparing legislative antidotes to COVID-19 conflicts. Obviously, that's a big subject and we can't cover the entire world. And I suppose in the same way that we hope that a vaccine will be the answer to all our personal prayers for good health, we look at the answers provided in different jurisdictions here today, which have been aimed at dealing with construction projects, conflicts caused by the pandemic. Can I just mention that there is a question and answer feature on the webinar, and if you want to send in some questions, we'll try and deal with them in the Q&A session after all my three speakers have spoken. So without more, I'll go to the first of my speakers, which is Dr. Helena Chen. Helena's a partner and joint head of office in China for Pinsent Masons LLP. She's well known to many of us, a leader in her field and uniquely qualified in Taiwan, mainland China, and New York State. She works both as counsel and arbitrator in cross-border investment and infrastructure projects. Helena, good evening. Over to you.
Thank you, Karen, for the kind introduction. Today, I will share with you the situations in mainland China. Can we get the slide on, please? Okay, great. Yeah. When we talk about PRC law, actually, there are a couple of jurisdictions in PRC, mainland China, Hong Kong, Macau, and Taiwan. And as you know, that Hong Kong law is actually more influenced by the common law system, while the mainland China law is more influenced by the civil law system. Therefore, immediately, after the outbreak of COVID-19, the Supreme People's Court of PRC organized a group of experts to prepare a study report on the law on force majeure in Hong Kong, Macau, and Taiwan. I'm personally involved in drafting the study report to explain the laws in Taiwan. But the law in Taiwan would be the topic for another day. Today, I will be mainly talking about the law in mainland China. Next slide, please. Article 180 of the PRC General Provisions of the Civil Law defines a force majeure event as any objective circumstances that are unforeseeable, unavoidable, and insurmountable. We can also find an identical definition: unforeseeable, unavoidable, insurmountable in Article 117 of the PRC contract law. It further provides in the PRC general provisions of the civil law that the force majeure, when the force majeure event prevents the performance of contractual obligations, the affected party may be partially or wholly exempted from its obligation or related liabilities if the purpose of the contract becomes futile because of this force majeure event. The affected party is entitled to terminate the contract. So it depends on how severe the situation is. In order to prove the occurrence of the force majeure event, many contractors in practice obtain a certificate issued by a government or a semi-government authorities, for example, CCPIT. Next slide, please. CCPIT is the China Council for Promotion of International Trade. I share with you a couple examples here, examples of that certificate. If you read the certificate carefully, you will find that the certificate only provides an objective description of what happened at that time. For example, what I show you here, it provides that the companies are forbidden to recover production before a certain date. You will notice that the certificate did not describe or label what happened as a force majeure event. Force majeure, the term itself, did not appear on the certificate itself. Nor did the certificate provide any causations between what happened and the companies applying for such a certificate, and any loss or damages suffered by the company. It did not mention any mitigation measures that the companies have or plan to take. So I always advise my client that to obtain a certificate is good, but it is only a starting point for you to pursue your claims, force majeure claims. It is not enough. You need to do more. And next slide, please. Another concept or adoption is the so-called change of circumstances, which is similar to force majeure but different concept under PRC law. It is defined in the second interpretation of the Supreme People's Court of several issues concerning the application of the contract law of the PRC. It is provided that where any major change that is unforeseeable, as you can see, it is also unforeseeable, and that is not a business risk and is not caused by a force majeure. So force majeure and the change of circumstances, these are two different concepts. Change of circumstances is not caused by a force majeure event, and which occurs after the formation of the contract. If the continuous performance of the contract is obviously unfair to the other party or cannot realize the purpose of the contract, then the party can file a request for the modification, amendment of the contract terms or recession of the contract with the People's Court. The People's Court shall decide whether to only modify, amend the contract or to rescind the contract itself under the principles of fairness and in the light of the actual situations of the case. So the takeaway today will be under PRC law, force majeure, change of circumstances. These are two different legal bases and supported by different articles in PRC law. So you need to think about which route you want to take. Next slide, please. A party who should a party should be able to explain to the court what happened are not business risk. So if that's business risk, the party, they have to bear their own business risk. If they want to succeed in its force majeure circumstances claim, they have to be able to explain to the court that these are not normal or usual business risk. And also the government, Chinese governments have promulgated several regulations in the earlier half of this year in order to help the construction sectors. For example, the contractors may defer or be waived to provide guarantees for wages to workers until the June this year, so the mid of this year. Nowadays, most productions have resumed back to, I think, nearly normal. So in the earlier half of this year, some business, small or medium business, can also request to defer or be waived of rentals to be paid to the state-owned enterprises. And there are also some tax reliefs. And then the most important is that the government has issued many guidance to help the companies to guide their workers to resume to work. So I think at the very beginning, they were kind of short of masks, but the government required that for all workers, they have to wear masks. So they will try to help their companies to get the masks they need. And also say alcohol to clean the environment, everything. And then also this one, the red dot here, is in Chinese characters. In English, it's the so-called Beijing Health. The people in Beijing have to download this app to their mobile because everyone carry mobiles everywhere, wherever they go. So they have to download this app. And for people living in Shanghai, they also have the Shanghai Health, another another app for them to download on their mobile. And then if the logo on your mobile under this app is green, you can basically go everywhere. But if it turns to yellow or even red, then your mobility would be restricted. So this is how the PRC government can very effectively control the COVID-19 situation. So that also concludes my sharing with you today. I hope that we can have some time to entertain any questions that you may have at the end. Thank you.
Eleanor, thank you very much indeed for that. My second speaker is Virpak Desai. Virpak leads the International Dispute Resolution and Investigation Practice at the well-known Indian law firm Nishith Desai Associates. Virpak is surely one of India's best-known practitioners in international ADR and works as an advocate, mediator, and arbitrator. Welcome, Virpak. Can I turn over to you now?
Sure. Thank you. Thanks, Karen, and thank you, IPBA, for inviting me for this seminar. I hope I am audible and visible as well. So I think we have talked about China, and in any world order, if you talk about China, I think you have to straight away, talk about India, and you can't avoid that comparison. So far as India is concerned, we can go to the next slide. I think I am going to, deal with the aspects first in reference to what was the situation prior to COVID, a very 30-second snapshot. And I think since last almost a decade, there was a huge focus from the government so far as construction and infrastructure sector is concerned. We not only amended our what we call as our specific relief act, which deals with specific performance of the contracts, where we made specific performance of a contract mandatory and not discretionary, in sense that even if in certain kind of contracts where one may claim damages or one can claim damages, but that person can choose whether to specifically perform that contract or they want to claim damages, and court has no discretion to go the other way. So I think that was a huge change which happened in last few years in India, particularly for the construction and infrastructure sector. And the enforceability of a contract became very, very viable. Not only that, there were measures taken for substitution of a contractor under the specific relief act itself. And in addition to that, there was a specific provision to say that there will be no injunction on a construction or an infrastructure project, even if there are disputes between contractor or a subcontractor or the government or otherwise. But court will be very reluctant to grant any injunction on the performance of the contract or the project itself. So I think there were several measures which were being taken for last few years. In 2019 December, government also came up with a scheme where if government challenges an award, there was a aspect of providing 75% of the awarded amount under the arbitration to the contractor, of course against a bank guarantee in case the government is challenging such an award, which means there was a aspect which was provided for better cash flow for the contractor. Then came COVID, and it was obviously somewhere in February 2020, March 2020, when the pandemic was in a way accepted. So far as India is concerned, we went through our lockdown from March 24 till May 17, which was a full lockdown of the country, including all the business establishment, and many construction projects also got affected due to that issue. We can go to the next slide. So first thing which is relevant for our discussions today is the Ministry of Finance memorandum, which was issued way back in 19th February 2020. And it specifically for the first time talked about the force majeure clause. And I will compare our law in a minute compared to what Helena talked about. But basically that circular said that a doubt has arisen if the disruption of the supply chains due to spread of coronavirus in China or any other country will be covered in force majeure clauses. In this regard, it is clarified that it should be considered as a case of natural calamity and FMC may be invoked. So this was the first time government on its own, in relation to their own procurement and supply chain contracts, talked about force majeure clauses and said that it may be invoked wherever considered appropriate. Now, just to take a step back again, what is force majeure from an Indian perspective, right? There are two situations. One, when there is a force majeure clause under the agreement, it is specifically governed under Section 32 of our Contract Act, which talks about contingent contracts. And basically it says that if the contract is contingent on happening or a non-happening of an event, then if such an event which was to happen or not happen makes the contract impossible to perform. The word here is one specific word, which is impossible. So if it becomes impossible to perform, then that contract is void. So that's how force majeure is covered under contingent contracts. If there is a clause under your contract, if there is no clause of force majeure under the contract, then also, unlike certain jurisdictions like UK and others where you have to fall back on jurisprudence, we have Section 56 under the Indian Contract Act, which again talks about impossibility of performance, and you fall on the measures and the provisions relevant under Section 56, which again talks about impossibility of performance. So basically, on 19th February 2020, Ministry of Finance came up with this circular, Again, unlike other jurisdictions like Singapore and others, where there were specific law enacted covering a lot of construction and infrastructure sector, we didn't come up with a specific law, but what we came up is with several different circulars and memorandums giving guidance as to how this pandemic will be addressed so far as this kind of construction projects or infrastructure projects are concerned. We can go to the next slide. So after 19th February 2020, there were certain circulars in March and April as well, but that all culminated into a very important circular on 18th May 2020, which is when our first lockdown period ended, or maybe second lockdown period ended on 17th May 2020. And Ministry of Road Transport and Highways, what colloquially is called MORTH, MORTH, came up with a circular which again talked about the contracts entered between the government or the National Highway Authority and others with the toll bridge or the toll road private operators. And it again talked about force majeure. It says that the lockdown, which was announced through 25th March 2020, would be considered or the words were may be treated as force majeure for the concession contracts as per the Ministry of Finance circular of 19th February 2020, which I just talked about. And it was directed that such a force majeure relief to the user fee collection to the contractors should be given by NHAI, which means that there are certain portions of the collections which are required to be deposited with the government for such toll roads, which are now not required to be submitted, at least for the period under which the lockdown was announced. Next slide, deals with a situation which actually went into the High Court of Delhi, and it dealt with this, May 2020 circular of MORTH, which we just talked about. And in that case, the contractor who runs the toll road went to the court to ask for an injunction for not allowing government to deduct the amounts which they are supposed to pay to the government against the toll collection, considering the pandemic. The court specifically interpreted this circular and said that there is no requirement for any additional notice to be given by the contractors because MORTH circular is very clear that this can be considered as a force majeure in a given situation. And it has continued because of very limited movement of traffic, and it continued almost till June, July in India, and therefore it gave the required injunction and also support to those contractors who were facing those problems. So I would treat these three things. One is your 18th February, then the May 2020 MORTH circular, and the the court's ruling on such a circular. In my view, that was an antidote specifically provided for such projects. We can go to the next slide. Those weekly payments by the contractors were suspended in view of the force majeure. So I think while Indian government didn't come up with a specific law covering several different aspects, but if you read these three things in it, together, and the aspects and the intention behind it, I think both on the issue of what can or cannot be considered as a force majeure event, what are the implications, and what are the antidotes in that sense, the contractors would be entitled to, was clarified through this judgment. We can go to the next slide. In addition to these circulars, there were several other measures which were taken by Ministry of Road Transport and Highways, MORTH. One very important aspect which the circulars which were issued time to time did was it gave guidance so far as contractors is concerned to grant extension of time under force majeure so far as those contracts were concerned, construction infrastructure contracts. So while we expected that there will be a lot of litigation and people will have to fight for every such situation, and every construction infrastructure contract will get into a dispute, but at least what our experience is, a lot of situations, considering this pandemic and the implications were implemented throughout the country, such measures were granted as extension of time. Even there was waiver of penalty for delay in submissions of performance security and bank guarantees. So these measures also allowed contractors to have that kind of respite, or at least some kind of support. We can go to the next slide. The measures continued, and government even announced release of a lot of retention money to the concessionaires to give the cash flow support so far as a lot of construction infrastructure projects is concerned. And in June 2020, the ministry even announced construction of further 15,000 kilometers of highway, which means that at least the industry had some hope in future for the purposes of this kind of measures. We can go to the next slide, which is my last slide for today's discussion. And not only in relation to construction and infrastructure project, as late as November 2020, Delhi High Court has also given the due support to infrastructure sector, including the airport sector, where a lot of airport are given to private parties for construction, operation, and maintenance. And there were several payments, due as part of the operational contracts with the government. And the Delhi government gave again an injunction for non allowing those payments to be taken away from the escrow accounts, so that the airport companies do not go into bankruptcy straight away. This again has given a big respite for the cash crunch this sector, aviation sector, has faced, which is also in a way related to construction infrastructure. And the last point about the real estate specific sectors for residential and commercial projects, the RERA, which is the Regulatory Authority for Real Estate Projects, which governs the timing for completing those projects, and puts penalty or gives a strict orders against the real estate developers, have also granted extension during the lockdown for completion of those projects. So all in all, in my view, Indian government has acted very, very swiftly and given the right support to this sector, which we are now seeing is, I would say, they have not completely come out of it, but they have also not suffered what we expected them to suffer in February, March 2020. So all in all, it's a good start, and I hope the government continues to provide this measures in support of this sector. There are many more things to talk about, but I will keep it for remaining time as part of question answers. And thank you again, Karen and IPBA, for giving me this opportunity.
Deepak, thank you very much for that. That was really interesting. So, ladies and gentlemen, my third speaker is Mirella Lechner. Mirella is a co-vice chairman of the ICP. But in her day job, she is an attorney at law and a partner in the firm of Wadiński and Partners in Poland. She works across Europe and Asia, advising clients on public procurement law, PPP contracts, and contracts using FIDIC forms. And today she's going to talk to us about the EU and the Polish position. Mirella, straight over to you.
Thank you, Karen. I just noticed we have Jack Lee on the line. Not sure if it's the time that he speaks for a moment.
Thanks. I was going to hand over to Jack when you finish speaking to make sure that you actually...
Okay. So I promise to be quick because we do not have much time. As you heard, I'm from Poland, but whenever at IPBA, I proudly represent European Union, which means 27 different jurisdictions. And in fact, in response to COVID-19 epidemic, each jurisdiction took its individual path to respond. In most of the European countries, there was a specific legislation to provide measures to first limit the spread of epidemic and also to support the economic operators that includes the construction sector. All these acts were called SHIELD or anti-crisis SHIELD. This was actually the line that was the response in every member state. But some actions in response to COVID-19 started or were initiated at the EU level. As you can see, some of the European Commission's actions, they were aiming also to preserving the construction industry. One, for instance, was related to closure of state borders. You can imagine that the first solution to be adopted by the member states in order to protect people's health was closing the state borders. But in fact, this would jeopardize the functioning of the internal market. This would threaten the circulation of goods, services, and also supply chains. So the contractors could suffer the lack of employees, deliveries, or the lack of access to subcontractors. So the Commission decided to control the closing of borders. Also, the Commission approved the flexible use of the state aid in order to support the economy, European economy in general. But apart from that, each member state actually consider whether or not the COVID-19 is a force majeure. Our speakers already talked about it. I mean, this was quite intuitive to go to the direction of force majeure in the kind of that event. It was in Europe, despite the force majeure definition does not appear actually in the domestic law systems, but it is, on the other hand, quite well recognized as a relief tool to relieve from the liability in case of improper contract performance. Traditionally, it covers natural disasters, acts of authorities, or armed conflicts, and unprecedented consequences of the COVID spread, and also introduction of unprecedented legal regulations to respond to COVID caused that in all member states, COVID-19 was considered a force majeure event. And as a result, different member states decided to adopt different measures in relation to specific construction investments. And as a result of force majeure concept, some of the countries suspended their construction investment temporarily, but for quite a long time because of the COVID-19. The solution in that respect were quite individual. For instance, in Austria, they suspended all construction investments for some time. But for instance, in Spain, only the public investments were suspended. For instance, in Cyprus, only private investments were suspended under the concept of the force majeure that applied because of the COVID-19. In Poland, for instance, none was suspended. It appeared to be quite resistant to the COVID-19 impact. As a result, further step was the tax relief granted to the contractors. It could take different forms, like for instance, tax relief or tax referral or assumption of the tax liabilities by the state, as it was in case of Croatia. Because of the suspension of construction investment, the obligation under the construction law had to be suspended as well. So the construction law is the administrative process that applies to all building permits or other approvals that are obligatory under the construction process. So the obligation was suspended, all the deadlines were suspended, or finally the procedure were facilitated. which means whenever previously an application was required, during COVID-19, only the notification was sufficient. And the final solution that was commonly adopted, and it was instructed by the state, was simplified and rapid payments. Actually, the contracting authorities, the employers, were instructed to accelerate the payment schedule in order to secure the contractor's cash flow because of the COVID-19 circumstances. And as usual, a special attention had to be given to the public procurement contracts, because as you can imagine, whenever you have a private contract, it is actually up to the parties in what direction they will agree to adapt the contract to the changing circumstances. But in public procurement, changing of contract is quite limited. Therefore, despite there was the force majeure concept adopted quite widely in Europe, there was a specific instruction to the contracting authorities to waive from delay penalties in public procurement contracts, and that was commonly adopted in the European Union. May I have another slide, please? But what also has been said today, that force majeure is the liability relief tool. It does not actually create a basis for the direct claim for compensation or for direct or indirect costs that actually may result from the external event. And again, in private contracts, the parties are to discuss and negotiate. In public procurement contracts, this may be a problem. And therefore, there was a legislative action required for the member state to authorize, to allow such further changes, such adaptation of contracts because of the COVID-19. And I decided here to put two examples. One is successful, the other one is not. So just to show you how different approach could be taken, different path, but actually aiming to the same result. Take the example of Poland. So there was the obligation under the specific law for the contracting authority to change the contract. This obligation had to be, or was supposed to be, a guarantee that the contract will be adapted. And as you can see on the slide, at the same time, the legislator deprived the contractors the right to withdraw, which usually would apply if the force majeure continues for the period of time. So there was an obligation and it was supposed to be a guarantee. However, the detailed proof of COVID-19 impact was required. And that is burdensome for the contractors, but also for the contracting authorities, because it appeared that none of the contracting authorities is really in a position to evaluate. And when we take the Czech Republic, you can see that the legislator offered something different, a flat rate compensation and a flat rate extension of time. And only in cases when the higher cost is required or longer extension is required, there is a documentation, special proof of an expert. For me, the most important difference in these two scenarios is that in the Czech scenario, the contracting authority is actually not liable if amends the contract according to the flat rate which is imposed by the law. In Poland, still the contracting authority is liable and the decision is on him. So this is why in Poland, we still have the claims on the table, not settled yet. And that is actually the whole scheme I would like to present to you, waiting for your questions.
Mirella, thank you very much indeed. That was really interesting. Well, thanks to all three of you. I don't think we, oops. In terms of questions, I have some questions, but in fact, I also saw that Jack Lee came online. Jack, sorry we didn't catch you earlier. Do you want to take 2 minutes now?
Okay. My dear brothers and sisters, dear distinguished guests, I'm glad to have this opportunity on behalf of IPBA to thank all of you to join our IPBA webinar at this special moment. COVID-19 virus has been spreading out around the world, but the virus cannot stop our mutual communication. Today, our seminar focuses on construction projects, comparing legislative antidotes for COVID-19 conflicts. Thank you for all our moderator and speakers for your great efforts for organizing this webinar. Last month, the 4th Regional Comprehensive Economic Partnership, RCEP, summit was held. After the summit, the 10 ASEAN countries and Asia Pacific countries, including China, Japan, South Korea, Australia, and New Zealand, formally signed the Regional Comprehensive Economic Partnership Agreement. The signing of the agreement marks the official start of the free trade zone with the largest population, the largest economic and trade scale, and the most potential for development in the world. I'm pleased to see that there is also a bright future of mutual benefit, win-win and joint progress between the RCEP and IPBA. To strengthen international and regional cooperation will surely become a valuable historical opportunity for the future development of IPBA as an international lawyer organization. Firstly, RCEP will provide IPBA with a wide range of service opportunities. Secondly, IPBA itself, as a regional and international lawyer cooperation mechanism, can take advantage of the historical opportunity of RCEP to further develop and increase its quality. Finally, the operation of the IPBA will also contribute to the smooth development of commercial cooperation under the RCEP framework and the implementation of the RCEP agreement. Opportunity knocks but once. RCEP is an example and a representative of the current and future international economic cooperation pattern. Next April, Shanghai will host IPBA 30th Annual Meeting Conference at the bend of Huangpu River from April 18 to April 21st. We are looking forward to meeting with all of you in Shanghai. I wish the webinar a great success. Thank you very much.
Jack, thank you very much for that. Well, we have almost no time left, but if I could just put one question to each of the three of you, and if I could just have a 1-minute answer. So we'll go in the same order, Helena, then Virpak, and then Mirella. You've described the measures that have been taken in the jurisdictions that you've covered. If there is one thing that has not been done, which you think has been, could have been done and should perhaps still be done, what would it be? Helena, have you any thoughts? Something which could be done?
Something which could be done. Well, I think if the whole world, including the management team of the government, could have that the general public know about what actually happened at the very early stage, which might be able to give us a little bit more time to react, to respond to this pandemic. But I think that after this is 6 months or more or longer time, I think overall the government has been doing very has been controlling the situation, at least in mainland China, very efficiently and effectively. And I think that is a lesson. There are lessons that we can learn from their experience.
Thank you very much. Virpak, what would you say?
So I think from my perspective, as I said earlier, I think, government did react on a timely basis on a lot of issues. But considering the scale at which India operates and the extent of different states' legislations, the labor law legislations, the construction infrastructure is heavily dependent on manual labors. They move between states. As you know, in India, things are, people move from one state to another, and a lot of construction projects happen on that basis. I think one thing I would recommend is to come up now for a long-term purposes. We have addressed a lot of issues on a short-term purposes, but this sector is going to get affected on a long-term basis. The way people work, the way people live, the way people, deal with infrastructure around them is going to change. The requirements were very different pre-COVID stage and post-COVID stage. So for a long-term perspective, in my view, to bring in uniformity of such measures, I think we need a central legislation or a central law enacted dealing in general with most of these issues, so that it is applied consistently across the country, rather than people struggle what will happen in Maharashtra versus what will happen in Delhi versus what will happen in Chennai. I think that, in my view, would be the need of the hour for a long-term sustainability of this sector. So that is one thing that I would suggest.
Thanks. Mirella?
Thank you, Karen. I would just focus on the construction contracts and ongoing projects, because I believe that they suffered the most because of the COVID interruptions and suspensions. And I would suggest that, well, mostly I would promote the Czech solution, because what I observe right now is the contractors are actually not knowing where they are when it comes to their claims, continuing of works and additional compensation that they claim. If member states applied a simple solution just to make the relation equal again, or sort of equal, to grant additional time and to grant additional cost to the contractors, that would probably be the easiest, the most practical solution for all the projects which are at the ongoing stage to further continue. Otherwise, there will probably be the threat of the court disputes, and I'm not sure how it is in other countries, but in Poland it is quite time-taking. It can take 10 years even to get whatever contractors claim. So I would promote practical solutions and releasing actually contracting authorities from the detailed evaluation of the impact of individual COVID-related circumstances on the contract performance, because I think it is not possible to do that. It is unprecedented to that extent that sort of practical and flat rate solution would be the most appropriate.
Thank you, Mirella. Actually, that's a very interesting point. And I've attended quite a few webinars, as I'm sure we all have. And there are a lot of people talking about, well, we need quick solutions. And certainly the Czechs seem to have adopted one. I mean, lots of other people are saying, well, let's use ADR, let's go to mediation, let's have a dispute review board or something fast and effective for contractors and for employers as well. But the Czechs seem to have come up with something quite novel and effective, as you say. So one final question, because really we're out of time, but this is quite a nice question. So let me just put it out to you. It says, and this is from Ronaldo Ma. In Brazil, back in March 2020, we saw lawyers opposing to the application of force majeure, defending a theory that outbreaks and its effects are and were foreseeable events, and they pointed to SARS, MERS, etc. And some even referred to Bill Gates, a video stating that a pandemic was coming. And indeed, I've seen other videos as well. Such a theory lost strength once the outbreak took worldwide proportions. But do any of you, as speakers, did you have any similar initial reactions in your jurisdiction? Good question. So let's go quickly round. Helena, any similar experience?
In China, I think at the very beginning of the outbreak, it's almost like a government position that it would basically regard this as a force majeure event. So we have like CCPI issuing certificates to help their Chinese contractors. So no, not at the beginning of the outbreak. But as of today, more than 8 months after the outbreak, then I don't think force majeure would be a strong would be a strong claim, because it has happened. So many months has already passed. So that's the situation in mainland China.
Not foreseeable anymore, you're saying. I agree with you. Virpak.
Yes, yes.
I think
No longer.
so far as India is concerned, I think for contracts like, lease and commercial lease or residential lease and other supply contracts, this was considered as disruption but not force majeure, because I think there were always an argument that still things are not impossible to perform. It may have disrupted the performance, and force majeure requires, as I was referring, the word is impossible. And I think while in India as well, government issued some of this circular saying that there may be a force majeure given this situation in circumstances that may apply. But I agree with Helena. I think once people go through each contract, if they negotiate on a good faith basis, nothing like it, which is what is happening in most of the contracts. Not many people are fighting. But if people go into contract by contract, facts by fact, then yes, there may be claims for extension or disruption. But it would be very difficult in many situations to claim force majeure. So that's my experience so far. But again, time will tell, because it's too early at the moment as to how this will still continue and how long. London has already gone through one second lockdown and now the vaccine. But I think every jurisdiction is dealing with it on its own pace, I would say, and so is India doing that.
Thank you. Mirella, final comment from you on that?
Well, as I said, for Europe, it was all unprecedented. So it was the force majeure unforeseeable from the beginning. The problem may appear while it continues. So it is not unforeseeable right now. But what we do in Europe, we tend to interpret the law as we do not require the event to be unforeseeable, but the impact of the event on the legal relationship. And if the problems appears, if for instance, the contracting party is not agreeing with our interpretation, we also have the solution which we apply, that we base our claims not on a force majeure, but on a change of law. Because in every European state, there was enormous introduction of dedicated legislation. So whenever you cannot relieve on the basis of the force majeure, you can reach out for the change of law clause, and you probably find yourself in the same contractual situation.
That's a good point. Thank you very much indeed. Can I thank you all very much indeed for your contributions today, and thank you for everybody for joining us. And can I echo what our president said earlier? Howsoever it does take place, we're looking forward to the annual meeting and conference in Shanghai in April 2021. Meanwhile, can I say to you all, please stay well, stay in touch in whatever ways we can. Thanks to Rhonda and the IPBA for helping us to put on the webinar. And wherever you are, enjoy the rest of your day, and season's greetings to one and all from the IPBA International Construction Projects Committee. Thanks all very much. And that's the end of the webinar. Bye now.
Thank you.
Thank you.
Thank you.
Thanks a lot.
Thank you.